Three minority MPs have filed an application at the Supreme Court seeking an interlocutory injunction to stop the May 1 implementation of the e-levy. The trio, MP for Tamale South Haruna Idrisu, MP for Boku Central Mahama Yariga, and MP for Northton Samuel Okujeto Ablakwa, are praying the Apex Court to halt further implementation of the e-levy until final determination of the substantive case. It will be recalled that the three sued the Attorney General and Minister of Justice over the e-levy, which Parliament approved on March 29, 2022. The plaintiffs argued in the substantive case that Parliament did not have the right numbers to form a quorum to pass the e-levy bill into law and prayed the Apex Court to declare the approval as null and void. In their latest application, the applicants want the Ghana Revenue Authority GRA, its agents, assigns and personnel to be restrained from carrying out the implementation of the e-levy. The court will hear the application on May 4, 2022.
Well, so there are many of raised questions, Portia, for instance, about how this injunction is going to prevent the implementation of the e-levy, because as the Finance Minister had indicated, the e-levy implementation begins May 1. And so this injunction will be heard May 4, 3 clear days from the day that's the implementation of the e-levy will begin on May 1. So we'll see how this pans out. But this is different from the substantive case which was filed on the 30th, challenging the e-levy itself on constitutional issues, specifically on 104.1 of the 1992 Constitution. But these are the details of the injunction that the three members of Parliament belonging to the minority NDC are seeking at the Supreme Court. First of all, a further declaration that by reason of the earlier relief above, the purported vote on the motion for the second reading of the electronic transactions bill by the 136 MPs is in contravention of Article 104.1 and therefore null and void and of no effect whatsoever. The third relief they are seeking as well is that a declaration that when the Speaker put the question to the House for their reading on the electronic transfer bill 2021, Parliament lacked the requisite quorum to pass the said electronic transactions bill 2021. Now, there's a fourth relief they are seeking as well. They are seeking a further declaration that the purported third reading and subsequent passage of the electronic levy bill is in contravention of Article 104.1 of the Constitution and therefore null and of no effect. I'll tell you what, Portia, there's a fifth relief they are seeking as well, that an order for the court to set aside the purported electronic levy bill by the 136 members of Parliament of the Majority Caucus present in the Chamber of Parliament on the 29th of March has been unconstitutional, null and void. So these are the five reliefs that the three members of Parliament, Samuel Okujeto Ablakwa, you have Mahama Yariga, and then also Haruna Idrisu seeking at the Supreme Court as it stands now. This is in addition to the substantive case which was filed on the 30th of March after the 29th of March said approval of the e-levy by the majority in Parliament.
See what happens.